And those issues will come before me in a court in various settings that we're going to talk about. When there's a contest over value as to the particular asset at issue, and there are different contexts that'll come before us. How does the bankruptcy case go through? A petition is filed. And once the bankruptcy petition is filed, what you'll hear is this order for relief is entered. It's not actually an order. It's just a term of art, but it stops everything. What's most important and fundamental, it creates a bankruptcy estate, which includes all of the assets of the debtor. The moment that case is filed, as of that second, it's docketed before the bankruptcy court. And then, more important to the debtor, there is an automatic stay. No one can come and look to get control over that property, levy on that property, garnish wages, anything the debtor owns or controls, whether it be a corporate debtor, a partnership debtor, an LLC debtor, or an individual debtor. All of it will be protected by the automatic stay.
The automatic stay, though, it's important to understand, does not stay the passage of time in most instances. So if you have a situation where if you have a hotel like this that files a bankruptcy case, but prior to that bankruptcy case there's been a notice of termination which has not become effective yet, the filing of bankruptcy will not stay that termination if there's no cure. So in other words, if I am a franchisor of a Crown Plaza hotel, and I notice Crown Plaza today that its franchise agreement is going to terminate 60 days from now, because in many states there are notice requirements as to when you can effectively terminate a franchise agreement. In California, for instance, it's 180 days. For almost no reason in California can you terminate a franchise agreement without giving 180 days notice. So in California, for instance, if I issue a termination notice to a hotel owner of its franchise agreement, and that hotel owner then files a bankruptcy case 60 days from now, on the 180th day, that franchise agreement terminates, notwithstanding whatever happened, notwithstanding the bankruptcy filing, so long as there's no opportunity to cure.
Dan, under 108, it doesn't automatically extend after 60 days?
It does not.
Really?
No.
Okay.
Now,
Doesn't apply. There are certain things that do automatically extend at least 60 days. So it may not be in the franchise world, but it's in a lot of contractual type of provisions.
now when we talk about the automatic stay, as I said, it stops all judicial proceedings, administrative proceedings, any litigation. It stops any and all attempts to take possession of property. And if you're a creditor and you continue and you ignore it and you take that foolish position, well, I didn't know about the bankruptcy, I can go ahead. Doesn't work that way. You're still violating the stay. You could be subject to sanctions and damages, including attorney's fees. The automatic stay continues on property up until the time it's no longer property of the estate, meaning a trustee has abandoned it, says, I don't think there's any value here for the estate. The property's underwater. Not going to help me, if I sell it, distribute any money to creditors. Or it'll continue until the debtor gets a discharge or the case is closed. Now, where we were going to see the first valuation issue, or one of the first valuation issues, and whether it be a Chapter 7, a 13, or an 11, you're going to see it over battles to get relief from the automatic stay.
So
That's going to be the creditor, usually a secured creditor, a lien holder, a mortgagee, coming in to say, I know there's a bankruptcy, I know I'm stopped, but really, Judge, for the following reasons, there are grounds to allow me to continue my foreclosure, to continue my attempts to collect, to continue my litigation. And that's going to be the litigation in front of us.
So before Dan touches on, some of those burdens and whatnot, the biggest thing, and you've got 2 packets of materials, but you'll see in the additional materials, the biggest question, the biggest single thing that I think all of us ask when we get the call, or we make the call to you as the expert, is the first question you should ask when you get the call from a trustee or from a debtor's counsel or whatnot is what? Anybody want to take a guess? Exactly.
Yes.
Exactly. Bingo. How am I getting paid? And that is so critical in a bankruptcy scenario, because a lot of people, the first question they ask when the judge was in private practice, and Dan and I, is how do you get paid? And we're not going to tell you that today. That'll be for the advanced seminar. Yes, Mike?
You brought up a good question on how I get paid. I do work for attorneys for bankruptcy. A lot of times I will collect prior to. The attorney will hire us, we'll go out to the property, collect from the property owner. It has been brought to my attention since I've got into this room that there may be a problem.
Right. So that, how do I get paid, segues, I think Michael is saying, is how do I get engaged? Because the engagement...
Or how to talking about how to keep the money he got paid.
Right.
Which is, we'll talk about.
So when you will see in this pack of additional materials, retention papers. And what's critical about that is, what Mike is correctly identifying, the judge is amplifying, is that debtors and trustees, when they're going to hire you to do the appraisal of this hotel, that's not an ordinary course of business expense. That's not like collecting the money at the Starbucks counter or at the check-in desk. That is a professional. You are deemed a professional because you have licenses or whatnot under Section 327. And so, the debtor and the trustee, this is different for a bank, for a secured creditor. But a debtor or a trustee who is engaging you, Mike, must get a court order from Judge Kaplan. I won't ask him what percentage of the orders he have deal with retention of professionals, but I bet you it's 25%. I mean, it's very significant.
Every professional, accountant, auditor, examiner, broker, appraiser, attorney, has to get court approval if they're going to be retained by a debtor or a trustee.
And two things have to happen. One, the court order, which you should insist on seeing, you should get before you do the job. That's critical, because there's all this funkiness. Another term that we won't ask Mike to say is called nunc pro tunc. It's not a good term, and it's not very clear you can do it. So when you get the call and you want to know how you're getting paid, you want to know how it's getting engaged, and you want to see the judge's John Hancock on an order, again, for a trustee or a debtor, that says you're authorized to be retained, and I respectfully submit, you should ask that order provide that you are paid either the fee or a retainer. Different judges handle this different, but depending on what your fee is, it's not unusual. As you know, a lot of you who do work day in and day out like to get half the money in advance and half at the time you deliver the report. Some judges will respect that, some won't. But again, it's so critical that you deal with this issue of getting paid. So you need the court order, and in order to get the court order, here's the last part of that. You have to execute what's called an affidavit of disinterestedness. You all know that from your professional licenses. You have certain rules under your regulations and state licensures, and Judge Kaplan has it under the bankruptcy code. Dan had a much more official-looking copy, but it's Title 11. You can't be related at all to any aspect of the outcome.
To the trustee,
right?
To the debtor. You can't have a professional relationship. You can't have a familial relationship. You can't be a creditor of the estate, so that you can't be owed money. Now, you need to disclose it all. And as part of your affidavit and your underlying application, you're going to tell me what relationships you have, whether they should bar you from being retained, how much you're looking to get paid, how you're looking to get paid, when you're looking to get paid, and that application is going to go on notice to the Office of the U.S. Trustee, to the trustee, to other parties in interest, who might come in and say, Judge Kaplan, don't sign that order. This is ridiculous. The appraiser is the brother-in-law of the debtor's principal. Of course they're going to be a high appraisal. You know, and it's better to address these issues now than at a hearing on testimony, and it's better to address these issues now before you've done the work than after you've gotten the work. Richard brought up a point. Nunc pro tunc, it means now for then. Great Latin term. Okay, and it happens when the application is submitted long after the work's been performed. And the appraiser says, Judge, I relied on the trustee. The trustee hired me. Debtor's counsel retained me. They were going to submit the papers. They were going to get the court order. What do I know? I'm an appraiser. I'm not an attorney. And I didn't get it. My bad. Can you approve the order now? And in our circuit here, in the Third Circuit, and in many circuits, the answer, I would like to give it to you. I believe everybody should eat, but I'm not permitted to. It is extraordinary remedy to go back nunc pro tunc. It is your responsibility as a professional not to rely necessarily on the debtor's counsel. And I can't go back and give you the court order after the fact, because that's just what it is, after the fact.
So I want to go back on this pay engagement. Most of you in this room have what I'll call standard letters. I highly recommend you use them. They're great. They spell out your responsibility, they spell out your rate, and I always recommend you have a two-tiered engagement. One is what it's going to cost to get the paper, you know, the appraisal, and what that is. And it's standard that's what I'll call a flat rate, you know, unlike, you know, Dan and I who run the meter. The second aspect of that is a lot of times you might be called to testify. It is best for you to put that rate right in that engagement letter, saying, I'm going to prepare this appraisal of the Crown Plaza Hotel for $3,500, and I'll deliver you the book with the pretty pictures and everything else required. But if you call me to testify in any process, it's going to be $150 an hour. That wouldn't shock the judge's conscience, and then you should.
No, I see their hourly rate.
Yeah,
believe me, $150 is a bargain.
Right. So, but you're better off to put it on the table right away than have to negotiate it or go back a second time. And again, and I would insist that any professional retaining you actually staple that and annex that as an exhibit to your affidavit or to the trustee or the debtor's application. Again, it's all about disclosure, as the judge said.